Well, a very good morning to everybody and welcome to the second day of this year's RLI annual conference. At this sixth annual conference on improving the refugee regime globally, moving from theory to practice, I'm really delighted to welcome for this session in a moment our distinguished keynote, Professor Jane McAdam. Before introducing her and handing over to her for the keynote presentation, though, I would just like to very quickly recap on the events of yesterday to highlight a number of points for those of you who may not have been able to attend. So we were absolutely delighted yesterday to be able to launch the first Refugee Law Initiative Declaration on International Protection, dealing in this case with externalization and asylum. And I'd like to reiterate my great thanks to the staff of the International Journal of Refugee Law, including Professor McAdam, for facilitating the publication of the declaration and the analytical paper. And we hope that that paper and the declaration itself will receive a great deal of attention and uptake in the coming weeks and months, especially given events globally. Talking about the other aspects of the panels, we were, first of all, led through a number of thematic issues relating to the general conference theme of improving the global refugee regime. Firstly, looking in a panel at how we frame those issues, i.e. how we should start thinking about improving the global refugee regime. In tandem, there was a panel looking at agents of change within the international refugee regime, thinking about who are the change makers in this particular area. And lastly, a panel looking thematically at complementary legal approaches to international refugee law. Where are the gaps in the legal regime and how might they be addressed? For the second set of panels, we looked at a wide range of open themes, i.e. themes unrelated directly to the theme of the conference this year. The first of those looked at approaches in national law to refugee protection. And of course, a wide range of perspectives from across the world were represented there. We also looked at what vulnerability means in contexts of displacement, of course, an ongoing and highly topical debate. And finally, there was an impassioned debate around the meaning of surrogacy in international refugee law to round off our open panels. Finally, the conference ended with a keynote from Professor Alex Aleinikoff looking at the arc of protection, a really good introduction to thinking more generally about this theme of improving the regime. Today, the second day of the conference, we look forward again to a number of exciting thematic panels. You can see those listed in your conference program, and of course, the Zoom links to join each of those are listed alongside the panels themselves. The first of the thematic panels deals with external processing. The second deals with how feminist theory might be a route into improving the global refugee regime. And the third of those looks at community sponsorship. Our last set of panels for today will be on open themes dealing with, respectively, internal displacement, rewriting refugee jurisprudence, including participation from refugees, and the theme of climate, disasters, and displacement. And indeed, this theme of climate and displacement has been a theme that has come up a number of times already in the conference. And for that reason, it is a particular pleasure to welcome Professor Jane McAdam as our keynote speaker for today. Many of you, of course, will know Professor McAdam as the director of the Andrew and Renata Kaldor Centre for International Refugee Law at the University of New South Wales in Australia. But if I can just say a few other brief points by way of introduction, I'll post her full bio in the chat function in a couple of moments. Professor McAdam is Scientia Professor of Law and Director of the Kaldor Centre. She publishes widely in international refugee law and on forced migration, with a particular focus on displacement in the context of climate change and disasters. She serves on multiple international committees and is, of course, Joint Editor-in-Chief of the International Journal on Refugee Law, which is the leading journal on refugee law in this field. In 2021, she was appointed as an officer of the Order of Australia for, quotes, distinguished service to international refugee law, particularly to climate change and the displacement of people. So with that short introduction, I would like to hand over to Professor McAdam, who will be talking to us this morning about moving beyond refugee law, putting principles on climate mobility into practice. A very warm welcome, Professor McAdam, and over to you.
Thank you very much, Professor Kaldor. It's a great honour and privilege to be able to be part of this year's RLI conference. And I'd like to thank the Refugee Law Initiative once again for convening such a stellar lineup and a global lineup. And I'd also like to acknowledge the invaluable work that you and your colleagues do in furthering law, policy, scholarship and practice, whether that be through academic research, teaching, or partnerships with practitioners, NGOs and others. I'd also like to pay my respects to the traditional owners of the land on which I am here in Sydney, the Darramurrugal people, and I welcome any Aboriginal or Torres Strait Islander peoples who are joining us today. Well, it was a sunny afternoon in Sydney back in late 2006 when a phone call came through from a community radio station. Would I do an interview about environmental refugees? Sure, I thought, that's easy. There's no such thing. As an international refugee lawyer, my touchstone was the 1951 Refugee Convention. And as we know, on its face, people fleeing the impacts of disasters or climate change or adverse environmental effects don't meet the refugee definition. And furthermore, at that time, a number of court cases over the years had expressly held that the Refugee Convention didn't extend to people fleeing disasters or other natural hazards. But this radio interview planted a seed that was to become the roots of my future work, namely, what legal protection does exist for people who are displaced in the context of disasters, environmental degradation, and climate change. Are there truly legal gaps, or are there gaps in our thinking about how existing legal frameworks might apply? And is refugee law, or even international protection, the appropriate lens through which to view the issue? What other bodies of law and policy might also be relevant? Today, I'd like to take you on a Kon-Tiki tour of some of these issues. As I do so, I'll try to situate my reflections in light of the conference theme, namely, how do we move from theory to practice in improving the global protection regime? And what is the role of international protection in the context of climate change and disasters, as opposed to other strategies? Last year, there were close to 24 million internal displacements linked to disasters. Climate change amplifies the frequency and the severity of extreme weather events. And what this means is that disasters will worsen and displacement will likely grow. In fact, climate scientists say that even if global emissions are reduced or stopped, the degree of baked-in climate change means that things are going to get worse before they get better. So this means that we're likely to see more and more people on the move. But as the Internal Displacement Monitoring Centre acknowledges, we still don't have great data about movement in this context. A lot of the numbers we have are based on proxy indicators, such as loss of houses. When people are evacuated, for example, many don't get counted in the official figures because they take shelter with family or friends rather than in official evacuation centres. And when it comes to cross-border movement, we have an even muddier picture. We don't have good ways of identifying who is moving away from the impacts of climate change and disasters, partly because people's reasons for movement are always multifaceted, partly because we don't have visa categories for counting who's moving in this context, and partly because there is often a time lag between initial displacement, which is usually internal, and subsequent movement elsewhere. And that might also affect how people describe their motivations for moving. Without accurate information, authorities and communities cannot adequately plan, prepare, or respond to disasters. In some contexts, the multi-jurisdictional nature of disaster responses, for instance, shared between national and local authorities or federal and state authorities, means that gaps, overlaps, and confusion can arise. International guidelines haven't addressed these problems in any depth, noting only that there's a need for cooperation where multiple actors are involved. Now, that said, we have certainly come a very long way in the 15 years since I first started working in this field. Our understandings now are much more nuanced and sensitive to local and regional variations. And we more clearly appreciate how climate change factors in as a driver of movement. There have now been cases brought before UN treaty bodies. There have been UN resolutions. There's lobbying for an International Court of Justice advisory opinion, and a new working group established within the International Law Commission to examine the legal implications of sea level rise, including with respect to displacement, migration, and planned relocations. One of the most significant achievements over the past decade or so has been the inclusion of language and action lines on climate mobility in multiple instruments, including the Sendai Framework for Disaster Risk Reduction, the Agenda for Sustainable Development, and the Global Compact for Safe, Orderly and Regular Migration. All of this has been aided by the creation in 2012 of the Nansen Initiative on Disaster-Induced Cross-Border Displacement, and then its successor, the Platform on Disaster Displacement, which have both served as institutional focal points and coordinating bodies to fill gaps, frame key messages, and facilitate regional efforts. When I look back over the past decade, there has definitely been a huge shift. For instance, when the Nansen Initiative was formed in 2012, there were still those querying if there was even a need to focus attention on this subject. That said, a decade has passed and hundreds of millions of people have been displaced during that time. A resurgence of nationalistic political parties and anti-migration sentiments around the world certainly haven't helped the cause. And while legal frameworks are starting to adapt, they won't provide all the answers on their own. There are still many people, including politicians and policymakers, who no doubt regard climate-related displacement as a problem of the future alone, rather than something of the here and now. As we've come to understand more about how climate change interacts with other drivers of movement, so we have been able to articulate more clearly just when and how refugee law might apply. Now, it has to be said, many people moving in the context of climate change and disasters will not be refugees, but some will be. And it's important to ensure that decision makers appreciate when, how, and why this may be so. In October 2020, UNHCR issued a document that sought to clarify the application of refugee law in the context of climate change and disasters. UNHCR emphasised the importance of understanding climate change impacts within a broader social and political context. And they noted, and I quote, that these impacts are often exacerbated by other factors such as poor governance, undermining public order, or by scarce natural resources, fragile ecosystems, demographic changes, socioeconomic inequality, xenophobia, political and religious tensions that sometimes lead to violence. They went on to say, as a result of these negative impacts of climate change and disasters, combined with social vulnerabilities, people may be compelled to leave their country and seek international protection. So rather than focusing narrowly on the disaster or the event itself, it's important to recognise that the social and political characteristics of the effect of climate change or disasters may interact with other drivers of displacement. As Matthew Scott has argued, we must appreciate, and I quote Matthew here, the deeply social nature of disasters, within which existing patterns of discrimination and marginalisation are exacerbated, which in turn can affect people's exposure and vulnerability to hazards. This also means that there's not really such a thing as a natural disaster. Disasters are always contingent on underlying social, economic, political, and environmental conditions. So the Refugee Convention may be relevant in a disaster context, where certain individuals or groups are persecuted by the government. For example, if the government withholds humanitarian assistance because people have undertaken disaster relief work, and there's been cases about that in New Zealand. The convention may be relevant where secondary impacts, such as increases in gender-based violence or discrimination with assistance or shortcomings in evacuation proceedings and the like, give rise to a conventional refugee claim. The Refugee Convention might also be relevant where the adverse impacts of climate change or disasters intersect with or amplify persecution for a convention reason. Or, of course, where convention refugees who are persecuted for reasons unrelated to a disaster or climate impacts flee across a border. Last year, a report released by the White House recommended that the United States assess how climate change intersects with the criteria for refugee status, including, and they listed the following: those based on environmental defence or climate change activism, cases where there's no viable internal relocation alternative because of the impacts of climate change, where people have relief from climate impacts denied or withheld on the basis of a protected characteristic such as race or ethnicity, or situations where climate change may impact a government's willingness or ability to protect people fleeing persecution. And this White House report also recommended that the United States create a specific legal pathway for humanitarian protection for people facing serious threats to their life because of climate change risks, noting that the United States has a compelling national interest to strengthen protection in this context. So, when it comes to the application of refugee law, and indeed complementary protection under human rights law, there's no need to reinvent the wheel. There's no need to create new principles or to make things overly complicated. Rather, the trick here is to show decision makers how to apply existing refugee law principles to the facts at hand. Climate change and disasters therefore provide a context in which the Refugee Convention or complementary protection may be engaged. What's important is to examine the impacts on people rather than the nature of the events per se. And of course, in this context, particularly when we're looking at human rights non-refoulement, we need to bear in mind that not everything that interferes with the enjoyment of a human right will necessarily amount to a violation of that right. That will only occur when the state, as duty bearer, violates its obligations with respect to a rights holder. And on that point, I'd like to come to the matter of Tessiota and New Zealand, which was the subject of a claim before the UN Human Rights Committee. The case concerned Mr. Tessiota from the low-lying Pacific atoll country of Kiribati. He had sought protection in New Zealand on the grounds that life at home was becoming increasingly precarious as a result of insufficient fresh water, overcrowding, saltwater inundation, erosion, and land disputes, owing to the effects of climate change and sea level rise. By the time the matter was heard, he had been living in New Zealand for about a decade with his wife and 3 children. He and his wife had originally arrived in New Zealand on 3-year work permits which had expired, and they'd missed important deadlines to regularise their status. In 2011, Mr. Tessiota was stopped for a routine traffic incident, and his visa status became apparent. By that time, it was too late to apply for a visa extension or permission to remain on humanitarian grounds. As journalist Ken Weiss explained, all Mr. Tessiota wanted was an extension of his visa. But what he got, and I quote Ken Weiss here, was an attorney who decided to present Mr. Tessiota as a casualty of climate change and set out to change international law. After 3 years of unsuccessful attempts before the New Zealand Immigration and Protection Tribunal and then courts, Mr. Tessiota was detained and issued with a deportation order. He lodged a complaint with the UN Human Rights Committee that same day, arguing that New Zealand would violate his right to life if it removed him, and he requested suspensive effect to stop that removal, which was denied. A few days later, he was sent back to Kiribati and his family followed shortly afterwards. The core of Mr. Tessiota's complaint before the Human Rights Committee was that the effects of climate change and sea level rise had forced him to migrate from Kiribati to New Zealand. He argued that the situation at home had become increasingly unstable and precarious because of sea level rise due to global warming. He said freshwater supplies were scarce because of saltwater contamination, that habitable land was being eroded, and as such, there was a housing crisis and land disputes that had caused numerous fatalities. In sum, he argued that Kiribati had become an untenable and violent environment for him and his family. Now, the Human Rights Committee accepted that, and I quote the committee here, without robust national and international efforts, the effects of climate change in receiving states may expose individuals to a violation of their rights under Article 6 or 7 of the ICCPR, that is the right to life and the right not to be subjected to cruel, inhuman or degrading treatment. And the committee said that would thereby trigger the non-refoulement obligations of sending states. The committee emphasised that the right to life includes the right of people to enjoy life with dignity, and noted that the conditions of life may become incompatible with the right to life with dignity before the risk is realised, meaning that protection should be forthcoming before the situation is imminently life-threatening. On the facts of the case, though, the committee found the requisite standard or threshold wasn't met. But this matter is significant because of the committee's explicit recognition that the impacts of climate change themselves may be a bar to removal. And what was also important was the committee's recognition that states have a continuing responsibility in future cases to take into account new and updated data on the effects of climate change and sea level rise, which means that future claims may have a greater chance of success. And in fact, even now, a different individual might already have a valid protection claim. Even without the formal value of precedent, strategic litigation like this Tessiota matter has an important role to play. It can highlight legal gaps or uncertainties and develop the jurisprudence. As Professor Guy Goodwin-Gill said recently in a different context, domestic courts have considerable potential as agents of development, which makes it all the more important that decision makers are increasingly familiar with international law, but also that the courts are provided with the best evidence of applicable law and of commonly accepted interpretations, especially because courts' decisions as organs of the state can amount to or contribute to practice for customary international law purposes. As well, litigation, even if, or perhaps especially if unsuccessful, can foster the urgency required for policy change. At the same time, it's also important to understand that the particular domestic framework in which jurisprudence is developed may colour the direction in which it goes. So, for instance, in New Zealand, decision makers have the power to grant a residence visa where there are exceptional circumstances of a humanitarian nature that would make it unjust or unduly harsh for somebody to be removed. Where this kind of possibility exists, there might be less of an imperative to push the boundaries of international protection. Although that said, New Zealand has really been a global leader on protection in the context of climate change and disasters, notably through the decisions of Bruce Burson, who actually considered the Tessiota matter at first instance. In any event, though, we shouldn't expect the international protection regime to hold all the answers or to have to do all the work. As many have advocated for a long time now, we need a toolkit of responses, including humanitarian and compassionate responses, as well as proactive opportunities for migration. These are not mutually exclusive, but rather complementary. Migration opportunities can help people to move in their own time and on their own terms, rather than being displaced and finding themselves dependent on the international community for protection and assistance. Migration also can provide a livelihood diversification strategy and reduce pressure on limited resources and build resilience. So the White House report I mentioned earlier recognised that migration is not only an important form of adaptation to the impacts of climate change, but sometimes an essential response. And the Global Compact for Migration commits states to considering the development of national and regional practices for admission and stay, such as by providing humanitarian visas, private sponsorships, and temporary work permits. As Professor Kaldor and others have shown, in some regions of the world, standard migration laws that facilitate movement for reasons of work, family reunion, education, and so on, can also allow people to move in the context of climate change. And in disaster situations, a lot of countries have expedited visa applications or applications for permanent residency from people from affected countries. In other parts of the world, free movement arrangements facilitate admission and stay in the aftermath of disasters. Of course, in all of this, we need adequate safeguards and oversight mechanisms to make sure that migrants aren't exploited. As Carol Farbotko and colleagues have argued, migration as a form of adaptation to climate change can have the effect of individualising responsibility for adaptation and thereby reproduce the structural inequities that contribute to vulnerability in the first place. So migrants and their families do have to be adequately protected and granted a domestic legal status that enables them to access essential support and assistance when required. This brings me to the final part of my address, which examines how governments in the Pacific region are proactively trying to harness climate mobility to create greater certainty, enhance resilience, and secure protection now and into the future. Pacific leaders have declared that climate change remains the single greatest threat to the livelihoods, security, and well-being of the peoples of the Pacific. Every Pacific country has seen people move in response to disasters, and this will likely increase as the long-term effects of climate change take hold. While many Pacific communities, if not all, regard moving away from home as an option of last resort, Pacific governments recognise that if movement becomes necessary, then considered and proactive responses have the best chance of ensuring that people can move in a safe, dignified, and rights-respecting manner. In February this year, I was appointed to lead a small team to develop a draft regional framework on climate mobility for the Pacific. And I'd like to acknowledge the other members of that team, Dr. Tamara Wood, Betty Barker, Sophie Offner, and Trish Tupu. This framework is being developed under the auspices of a joint working group on climate mobility chaired by Tuvalu and Fiji, as well as under the auspices of the Pacific Climate Change Migration and Human Security Program. It's been an enormous privilege to work with Pacific governments, affected communities, and other stakeholders to develop this draft framework. And I should stress that my comments today are personal reflections and do not necessarily represent the views of Pacific governments or any others who are engaged in this process. The draft framework is a comprehensive document that seeks to guide Pacific governments on a broad range of actions to help them plan for and manage the movement of people within and from the region, while at the same time it seeks to identify strategies to build people's adaptive capacity to stay in their homes for as long as possible. We were asked to consider a wide range of issues, including climate change, disaster risk reduction, migration in all its forms, planned relocation, human rights, labour rights, statelessness, and citizenship. The framework is grounded in core Pacific values of trust, respect, and care for people, for knowledge, for land, and for sea. It draws on laws, policies, and practices from the Pacific region, while also taking inspiration from a range of global and regional frameworks and guidelines. And it seeks to emphasise that at all times, the culture, heritage, and human security and rights of individuals and communities must be safeguarded, and the needs of vulnerable or marginalised groups acknowledged and protected. Just last week, we held consultations in Fiji with governments, civil society, and other stakeholders to discuss the first draft of the framework. We're now working towards a final draft, which will be presented next month, and then handed over to Pacific governments, which this is their framework. They will see it through then for further consultation and hopefully for eventual endorsement by Pacific leaders. Regional approaches to climate mobility like this are essential. And in fact, one of the core conclusions of the Nansen Initiative was just how crucial the role of regional and sub-regional actors is in complementing national efforts to find solutions. The Pacific Regional Framework on Climate Mobility is a world first, which means it's an extremely exciting opportunity. But at the same time, it's also very challenging, especially in a region as diverse as the Pacific, where countries' geographies, capacities, and opportunities for movement differ greatly. Some Pacific countries are low-lying atoll nations. Others are comprised of low and high islands. Some have special ties to other countries that allow them to migrate. Others don't. Australia and New Zealand are also part of the region, and their laws and policies will probably play a large role in determining how extensive some cross-border mobility can be. While different regional frameworks and approaches can, of course, take inspiration from each other, they're not directly transferable. In the Americas, for instance, there's a long history of people crossing borders to escape the impacts of disasters. But in the Pacific, the geography there, which is described as a sea of islands, has only one land border between Papua New Guinea and Indonesia, so movement looks very different. Pacific peoples' past experiences of migration or relocation, their religious beliefs, their age, their connections to land and sense of identity all affect how mobility is viewed as a response to climate impacts. For example, I've heard older people say they never want to leave their homes. People are worried about the social, emotional, spiritual, and cultural losses that come with being dislocated from land, which go to the very heart of identity and well-being. In fact, in a lot of Pacific languages, the word for land is the same word as placenta. So land is something to which you belong, not something you own. And people's whole sense of being is linked very much to place. At the same time, we have to recognise that people's ability to stay in their home can be aided by options for movement. So, for example, access to labour opportunities in other countries may enable people to achieve greater security to support their lives at home for longer. Some Pacific countries' approaches to mobility have also shifted over time, from outward-focused advocacy on migration with dignity to more inward-looking focuses on resilience building and internal migration. And I've seen that in the 15 years that I've been working in this region with these different approaches from time to time. Despite the extreme risks posed by climate change, voluntary immobility can be a deliberate political and cultural choice to stay in place and maintain connections to home. And Carol Farbotko, who I mentioned earlier, has done a lot of work on this. During the pandemic, there have also been some fascinating practices emerging. So in Tuvalu, many people left the main island, which is generally the place people are going to for work, and they return to ancestral lands in outer islands. So here, customary land tenure, which is sometimes seen as an impediment to relocation, in fact, facilitated mobility. It's also a challenge to reflect fundamental principles of dignity and protection in a meaningful way, where people can really see this as having their lives empowered and having protection and assistance forthcoming, while also having the agency and resilience and authority and decision-making power to be able to move or not. And finally, I think we commonly think of regional approaches as demanding harmonisation, but the Pacific often talks about unity through diversity. So collaboration, coordination, and cooperation can be ways of implementing regional priorities, while also leaving it sufficiently flexible for individual countries to tailor their responses attuned to their national priorities. And in that sense, I think national practices too can be supported by ongoing regional dialogue and the sharing of lessons learned. So in that sense, regional cooperation is a way that countries can address common challenges and promote the advancement of all peoples. So in conclusion, returning to the question I posed at the beginning of this talk, how do we move from theory to practice in improving the global protection regime? And what is the role of international protection in the context of climate change and disasters? Well, in response to the second question, I hope it's been apparent from my remarks that international protection can have a role to play here. Even though there's no such thing as a climate refugee as a matter of law, there is such a thing as a refugee whose circumstances are made worse because of climate impacts. Decision makers and policy makers need to be educated about the kinds of scenarios in which protection needs can arise. Both international refugee law and human rights law contain principles that affect what states can and can't do when they're faced with people whose lives or well-being are at risk from the adverse impacts of disasters or climate change. And these principles should continue to evolve in light of changing circumstances. When it comes to the first question I posed, well, the past 15 years have provided a case study in moving from theory to practice. Research on climate mobility has gone from a niche topic into a burgeoning area of scholarship, of policy development, and of practice. The voices, knowledge, and advocacy of affected communities has been critical to this, with regions like the Pacific really leading the way with progressive policies and practices and this world-first climate mobility framework. On the one hand, this is no cause for celebration at all, because it reflects the fact that people are being displaced right now and are urgently seeking solutions to prevent future forced movement. On the other hand, we are seeing really creative, innovative, and evidence-based strategies emerging, which are aimed at building resilience so that people can stay at home where possible, while also fostering safe opportunities for migration when necessary or desired. So while international refugee and human rights law can certainly provide protection for people impacted by climate change and disasters, I believe that a more sustainable approach lies in a suite of options that afford people agency to decide if, when, and where they will move. Thank you very much.
Many thanks indeed, Professor McAdam. An absolutely brilliant talk to start off our second day, really get all of the wheels turning in our heads as we try to grapple with some of these big issues. One of the things that I really like about the way that you've presented the issue is that when we think about climate change and its impacts, it sometimes seems an enormous, absolutely insurmountable problem, something that individuals and even countries will struggle to grapple with. And certainly there's a degree of truth in that. But I like the way that your talk sketches out a progress from really a lack of understanding of what's involved in this area to a greater degree of understanding. And in fact, some degree of optimism in the way in which states and other actors within the migration space, the protection space, development, etc., are in fact trying to deal with this issue of movement, or we say an issue of movement. I think that there are many issues of mobility, including immobility, as you pointed out. So a really very, very thought-provoking intervention to start us off with. I can see that you've started to garner quite a lot of questions already, but I wondered if I might just very quickly abuse my position as chair and ask if you could speak to a couple of general points that I think might set the tone for some of the later questions. The first of those is we were talking a little bit earlier, you and I, about the new special rapporteurship on climate change and human rights, and the fact that this rapporteurship has identified 6 priority areas of work. One of those, in fact, being climate refugees. And I just wondered, climate refugees obviously was a term that was invented a while ago. Where did it come from? Why do you think it continues to have purchase? Why do some scholars, François Germain and others, defend it as useful? And where do you position yourself personally in relation to that? And I suppose my second question is, the Pacific, as you've outlined, really is a fascinating regional case study. And I think, there is a good deal of merit to this argument that different regions have rather different sorts of challenges and opportunities concerning mobility in the context of climate change and disasters. Do you think that, there is in some future landscape a possibility of a global approach? Or are we, when we respond to this area, thinking predominantly that these approaches will stay regional over the longer term? So I can see you've got probably another half dozen questions after that. So if you wouldn't mind addressing those two fairly briefly, then we can move on and post some of the other questions that people are asking. And please do continue to post them in the chat box. Over to you, Professor McAdam.
Thank you very much. Yes, well, I mean, I think it shows where we've got to, that we now have a special rapporteur who's specifically looking at climate change and human rights, given that there are other mandates that intersect with this. And of course, some of the very early work there was done by Walter Kalin when he was in the role of the Secretary General's representative on the human rights of internally displaced persons, which then became a special rapporteur role, and that work continues with looking at IDPs and climate or disaster-related displacement. I think, this climate refugee framing pops up from time to time. And back in 2012, when the Nansen Initiative was formed, the language of what do we actually call these people was put to one side, because it could have taken the whole 3 years of the Nansen Initiative's work to come up with terminology and framing. And I think partly as lawyers, and if we're looking very technically at this, the language of climate, for all the reasons I pointed out, this sort of climate refugee framing is not necessarily helpful, and can in fact serve as a distraction at times as well, because it takes a particular viewpoint. It assumes people have already been displaced, and we used to get into all these questionable issues about, well, how do you know climate change is the cause, and all this sort of stuff, this scientific questions of causation, which I think is why this sort of social context of disasters is a much preferable approach, and enables us to see how the Refugee Convention can apply. The climate refugee terminology as well. I mean, one of the other things I found from the early research I did in the Pacific was that people hated the term. They didn't want to be called climate refugees. Unfortunately, one of the reasons was that they saw refugees as victims who were dependent on handouts, which isn't the way I see refugees, but that quite negative stereotype meant that they didn't want that ascribed to them. But I think as well, the reason you mentioned Francois Germain, the reason why he has he said he's done a 360 and come back to that term. He said, climate refugee has a certain political resonance to it, because it does suggest that there is damage being done by states here. This is not some natural phenomenon. And so for him, that sort of reclaiming of the language may reinsert some of the political impetus into it. Personally, I still find it problematic for the reasons that I have mentioned. And I think too, as I mentioned in my talk, we're finally, I think, getting to this point where we're trying to show decision makers, officials, that there's nothing new or tricky here to see. It's really continue applying the Refugee Convention as you have, but don't immediately see a disaster or climate change claim and assume it can't apply. You need to think it through in these kind of scenarios. So I suppose that's why if you start creating a new label, people might think there's a whole new category as well. In terms of the question about do we need a global, or will we ever see a global approach? I mean, I think that, if the world's governments decided they wanted to create some new special protection, sure, go for it. But I don't see that happening at the moment. And I think as well, there is value in recognising where do existing principles get us, and where are the gaps beyond that, and how might they be met. The other thing too is, if I reflect on the various regional processes I've been involved in, and seen the challenges of even getting agreement there, and these aren't treaties, mind you, these are, we've been involved in other ones, guidance, guidelines, very much voluntary commitments. There is a lot. There are a lot of regional differences, diversity within the region. It can be quite hard to get people onto the same page. So I think, the global level, there are certain things like sustainable financing that is absolutely crucial, the issue of loss and damage, mechanisms for aiding those who, whether it be through migration or whether it be through funding or technical assistance. So I think each level has a particular role to play here. And as I say, at this point in time, I don't see a new kind of arrangement, treaty, anything like that being forthcoming.
Thank you very much. I'm going to turn now to some of the questions that we've had from other participants, and I'll give you perhaps 3 or 4 just to kick off with, and then perhaps the second or even third round, depending how quickly you go. So the first question is about, well, if we're going to rely on migration frameworks, is there a danger of overlooking the protection needs of forced migrants? And you did touch very quickly on that point, but how might one resolve that issue? A second point that's been raised is about causation. And here we're talking specifically, I suppose, within the kind of the refugee or international protection framework. And one of the questions here asks, well, what are some of the best practices for refugee law practitioners to address issues of causation and evidence in the context of protection cases with a climate or disaster dimension? And closely related to that, there's a second question about causation here, which says, if human agency is needed to establish persecution or ill treatment under the Refugee Convention or human rights law in the context of international protection, what do you think the correct causal test should be? Should it be, as per the European Court of Human Rights in the case of Soufi and Elmi, a test of predominant cause, or do you think that that is too stringent, or perhaps too wide? And perhaps the last question, just on a slightly different topic, is how do we move beyond what seem to be traditional state-based approaches to displacement, particularly in the context of disasters, that focus on avowedly temporary responses, to something else that gives a longer-term set of solutions for people who clearly aren't going to be able to go home anytime soon? So I know we've got a number of other questions there, but if you would like to take those as a first round, we'd be delighted to hear your thoughts on them.
Thank you very much, and thank you to everybody for for compiling such thoughtful questions. I very much appreciate that, and you're challenging me too. Maybe just to the last one, I think this idea of temporary versus permanent or durable protection is has been a real challenge, because if you look at the Global Compact on migration, there are references to providing, or even some of the regional frameworks to sort of to providing humanitarian options, temporary admission, temporary stay, until it's safe to go home. And I think the United States in the White House report kind of highlight in a sense that we're leading ourselves on if we think that's going to be appropriate in all cases. Because if you look at the United States with their temporary protected status, they've got cohorts of people who have never been able to go home, and they have to be transitioned onto something more permanent. And I think too, looking now at the situation with Ukraine and Europe's response, that's been remarkable on the one hand, but on the other hand, I do wonder whether there's this idea of, you help those who are geographically proximate to you, and you provide temporary protection until it's safe to return. I hope that doesn't now become the sort of dominant paradigm here. Obviously, most people want to go home if they can, but very often they can't. So I think that is also where this idea of giving migration opportunities, even if they begin as temporary ones through seasonal work, but having a pathway whereby people can remain for longer. Australia and New Zealand to some extent do that, but they don't label it as climate mobility, even if these days that's kind of at the back of, or even at the front of people's minds. And if I can just give an example here, New Zealand for a number of years has had this thing called the Pacific Access Category, which enables a certain number of Pacific Islanders to migrate to New Zealand permanently each year. Now, it was never framed in the context of climate change, but it is seen as a mobility option there. And we had been advocating in Australia for something similar. The new government has suggested that they would provide 3,000 permanent visas to Pacific Islanders on an annual basis, partly because the options that exist at the moment are all temporary ones, and they just don't provide that longer term security or a pathway for people to be able to remain. And I think, sorry, and then in terms of those protection needs, unfortunately, some of those seasonal work schemes have drawn enormous attention to the way that people can be exploited at times. And I think during COVID, when Pacific workers were stuck in Australia, some of them were living in really dire conditions, and their employers basically, threw up their hands and didn't assist. That doesn't have to be and should never be a feature of a scheme. And I think we need to be absolutely attuned to the conditions that people are given in terms of their visas, but also what actually happens on the ground. Because again, the Pacific has a very long history of forced labour schemes, and this isn't supposed to be some sort of guest worker, second-class citizen, or not even citizen status. And that is something there is a huge amount of documentation on, literature on, and I think constant revisiting to ensure that people are adequately protected. In terms of the questions about causation, I guess this is where I would again sort of try and look at what is the actual harm that people are at risk of, as opposed to what's causing it. Because I think we can find ourselves in a very complicated spiral, and one that is quite unhelpful if we start to try and drill down to, well, what's the primary cause of this movement? If instead we can look at what are the impacts on individuals and what are the rights that are at risk and why, that I think is a more productive way through. And just one thing, if I may mention about the Human Rights Committee case, was I think a lot of confusion has arisen there. I don't know that it's what the committee intended if you read the case very closely, but it's certainly been interpreted as requiring harm to be imminent, that you can be sent back until harm is imminent. That's notwithstanding the line in the view that says harm doesn't have to be imminently life-threatening before you shouldn't be sent home. But I think that's dangerous, because that imposes a much higher standard than is part of existing protection law. It shouldn't be a standard, it's the wrong standard. But I think it's very unfortunate if that message is being taken away, because instantly you can see that bar being raised incredibly high. And that then starts to close down the opportunity for the principle of non-refoulement to operate as a protective principle in this context.
Many thanks indeed. We've got a lot of other questions coming in. I think some of them you've managed to answer as part of your response to the first round of questions. But if I could just pose possibly another 2 or 3 questions before we draw the session to a close. The first of those asks again about what can other regions learn from the process of creating this draft framework in the Pacific, particularly thinking in terms of the process, how did one get from A to B, as opposed to perhaps what the content of the framework is specifically. There's a further question which asks, I've lost it now, but asks broadly about the research agendas. So what are the research priorities in this burgeoning field of scholarship to ensure that we actually do move from theorizing about movement in the context of climate change and disasters to improving practice? So what research priorities would you identify there? And the third question, actually from amongst a great many of them, is asking about, well, you've talked about the fact that mobility in these contexts reflects an intersection of various social factors. But what about where you've got the intersection between disasters or climate change and armed conflict? How should policymakers or decision makers, particularly within the international protection space, be reacting to those sorts of situations? How do they kind of get a grip on those? So if I can leave you with those few questions, I think you've got about 6 minutes to go.
Wow, this is really challenging now. Speed answering. They're all great questions, and I will not be able to do justice to them. Can I just clarify? The first one was that what can other regions learn? Was that the essence of it? Yep. Well, I mean, I think, as I said, yes, there's going to be great regional diversity, sub-regional diversity, but I think there are certain core, what's the word, elements of, I mean, if you look at modalities of movement, displacement, evacuations, planned relocations, migration, there are certain common elements to those and rights that need to be protected and safeguarded at different phases, and so on. And while a planned relocation may look a bit different if you've got freehold land versus customary land, there's still that wrench from place. There's still the need to be having full consultations with affected communities, whether they be those moving, those arriving in the diaspora, the host communities, and meaningful, effective consultation with consent. And what happens? How do you decide? What happens if some people don't want to go? What kind of compensation might there be? And how do you ensure that all members of those various communities are being properly consulted? I think in some of the the process of how these things should happen, the overarching guiding principles, what are you trying to safeguard here? How are you ensuring that particular groups' rights are being safeguarded along the way and their interests heard? I do think there's a lot lessons that can be learnt, and also when it comes to accountability, also when it comes to the kind of data that we need to have to hand to be able to rely on. As I mentioned, it's really not very good at the moment, which, in terms of that research agenda, this isn't necessarily legal research, but I think there is still so many, despite everything that's happened in the last 15 years or so, and obviously it's not only 15 years, that's my engagement with this. I think that, we are still learning what we don't know, and how much of the data we have is not properly collected, shared, analysed, disaggregated. As I said, having the number of houses lost as a proxy for how many people are displaced, that's imperfect. We also don't have a great sense of how many groups are being displaced over and over again. We know it's happening, but different people are going to have different tipping points as well. And how much of non-movement is a sign of vulnerability versus a deliberate decision. And how do we define vulnerability? I think that's also been, I know that's part of the conference theme as well, but I think, for example, in the Pacific, people don't want to be, yes, they recognize they're in a vulnerable situation at the same time as they say, but we're not vulnerable. We are strong, resilient people with capacity, and we are finding our own solutions. And that, I think, would be my biggest point on how do you move from theory to practice so that it's not completely abstract. Engage with people with lived experience. Listen to them, work with them, partner with them, facilitate them, because they have a lot of the answers. They just may not have the channels or the finances or the resources to implement them. And I think that's, as I said, been one of the biggest and most positive changes in the past decade or so, is really having those voices elevated and heard. The nexus between disasters and conflict, I mean, this is where we're getting cascading issues. It's this on top of that. And while there's been a lot of ink spilt about, is climate change itself a driver of conflict? Is resource scarcity? I mean, I think we know resource scarcity certainly can be. I mean, if I could just refer you to some of the work that Sanjula Weerasinghe did for UNHCR on this, looking at those intersections, that might, if you're not familiar with it, that might be very, very helpful. But again, that's where I'd come back to that point about causation. Yes, it's important to look at the big context in which people are moving and what may make it safe or not for people to return in the long term, but to understand that the intersectionality of those things, and also how it impacts on different individuals depending on their particular circumstances.
Fantastic, and dead to time. So many congratulations on that. I know that they were tricky and big questions to answer, but you gave a really full answer to each of them. You've been very generous with your time and with your expertise and experience in this area, and I'm really extremely grateful. On behalf of the RLI, I would like to thank you again for agreeing to come and deliver this keynote on day 2. It's given us a really fantastic platform to move forward in the conference, and it is one of those issues that keeps on recurring in discussions about international protection, and indeed is a matter of great interest. So much so, in fact, that we last year started a module on climate and disaster displacement on our distance learning MA in refugee protection. And of course, that draws a great deal on the work of people like Sanjula Weerasinghe, whose details I put in the text box, and of course, Professor Jane McAdam as really one of the first people to start working seriously on this issue. It has been an enormous privilege to have you with us. I think we will draw the session to a close here.